So welcome to the HR Huddle. For those that aren't aware, I'm Eloise Shelton of Vanilla Recruitment. We specialise in HR, accountancy, office and marketing. We recruit across the East Midlands. So today we're joined by Keeley Baigent of KSAB Law, and she's going to share with us case law developments that have happened since December and some of the court tribunal decisions focusing on discrimination. So today's session is going to last approximately an hour. If you have any questions, please feel free to put them in the chat box, and Keeley and I will get through them as quickly as we can for you. So thank you for joining us, and I will pass you over to Keeley.
Hello everyone, and welcome to today's HR Huddle. As Eloise said, we're dealing with case law, mainly updates that have occurred in the last 6 months since our last webinar, which was in December on the same topic. So there has been quite a lot of developments actually, but it's strange because it seems that, all of those cases, or many of the discrimination cases, are all on the protected characteristic of religion and religious belief. Not all of them, but quite a large sum of them. So it's just odd, isn't it, how these things happen, and whether it's trends or whether it's just coincidence. It is a bit peculiar, but we're going to be covering a range of topics, and we're going to cover long COVID, whether that is determined to be or could be a disability, whistleblowing, discrimination, as I said, mainly in the area of religion or religious belief, agency workers, vicarious liability and holiday pay. So I'm going to share my screen to allow you to see the slides. Hopefully everyone can see that. Please feel free, as Eloise said, to drop any questions in the chat box as we go along, and then Eloise will be able to alert me to those questions that hopefully I'll be able to answer for you. So we're going to have a look first of all then at long COVID. Is it a disability? And this was a matter that was considered in the case of Burke and Turning Point Scotland, in which an employment tribunal had to consider whether an employee with long COVID symptoms was disabled within the meaning of the Equality Act and Section 6.
What are you looking at?
The
really handsome now.
Oh, I can hear. Is that because Eloise? I think there might. I'm not sure whether everyone's muted.
Yeah, would everyone mind muting, please? There you go.
Oh, okay, lovely. So, so the background to the case then is the actual definition. We've had a look at this many a time, so we probably all know it off by heart. A person has a disability if they have a physical or mental impairment which has a substantial and long-term adverse effect on their ability to carry out normal day-to-day activities. And I have underlined the aspects of the definition that we need to consider in making the determination in respect of any individual. The facts then of the case are that Mr. Burke was employed by Turning Point as a caretaker from April 2001. In November 2020, he tested positive for COVID. Initially, his symptoms were mild. However, after isolating, he developed severe headaches and fatigue. After waking and showering and dressing, he had to lie down to recover and struggled standing for long periods. He could not undertake household activities like cooking, ironing and shopping. He experienced joint pain, a loss of appetite, a reduced ability to concentrate and difficulty sleeping. He also felt unable to socialise. The symptoms were unpredictable. He would experience improvement only to suffer from fatigue and exhaustion again. And from January 2022, his health began to improve. However, sleep disruption and fatigue continued to affect his day-to-day activities. He remained off work from November 2020 all the way through to when he was dismissed, which was in August 2021. Fit notes referred to the effects of long COVID and post-viral fatigue syndrome. By contrast, however, there were 2 occupational health reports that were obtained by the employer, and they actually made reference or provided an opinion that the expert didn't believe that Mr. Burke satisfied the definition of disability in the Equality Act. His symptoms relapsed and he didn't return to work. And as I say, he was dismissed in August 2021 because of his ill health. He subsequently brought a disability discrimination claim, among other claims as well. So as a preliminary issue, the tribunal had to determine whether or not he had a disability during the relevant period. I wonder what your view is on it, because we've got on the one hand, the occupational health report, both saying it's unlikely he satisfies the definition of disability at the relevant time. But then we've got contrasting to his view, or what he is saying about his symptoms and the impact and effects of the condition. Very tricky, but quite common. So let's see then what the Employment Tribunal said. They concluded that he did have a disability at the relevant time. The tribunal determined that the effects that he was saying he was suffering weren't exaggerated. And they considered, well, what incentive has he got to remain off work, stating that he was suffering with these symptoms on the basis that he had exhausted all sick pay. So in effect, they considered that there was no real financial incentive for him to do that. There was a lack of particularisation within the initial fit notes that the employer did rely upon, but the tribunal said that that was most probably because of the fact that at the time GPs weren't conducting face-to-face meetings. It was all being done remotely. Also, his fluctuating symptoms were consistent with the June 2021 TUC report. The Employment Tribunal considered each element of the definition of disability. They considered that Mr. Burke had a physical impairment, that being the post-viral fatigue syndrome caused by COVID-19. That physical impairment did have an adverse effect on his ability to carry out day-to-day activities. The effect on day-to-day activities, in the tribunal's view, was more than trivial or minor, and therefore it did have a substantial adverse effect on his ability to conduct day-to-day activities. In respect of the long-term aspect of the definition, the tribunal considered the effects were long-term because assessed at the relevant time, i.e. the date of dismissal, it determined that the effects could well, and that's the consideration, could well continue to occur for 12 months or more. The tribunal noted that the employer's own view at the time was that there was no date when a return to work seemed likely, which supported the view that it was likely or could well happen that the effects could last for 12 months or more. So what can we take from this case then? It highlights again the importance of considering each aspect of the definition of disability in trying to determine if an employee could have a disability. And it's for us to make that determination at the relevant time. Obviously, if it gets to an employment tribunal, that's the role of the employment tribunal judge. However, all we can do is look at what symptoms and effects of the impairments the employee is saying they're suffering with at the relevant time, what impact the individuals are saying that condition is having on their ability to conduct day-to-day activities. And of course, we obtain an occupational health report. However, because of this case and because of other cases too, we shouldn't rely completely on the occupational health report in making or assisting us making a determination as to whether or not the employee could have a disability. So what can we learn? Tread carefully. Okay, so I'm going to move on then to the next area, which
just
is...
Before, Keeley, just before
Yes.
you move on,
Yes.
there was a question from Corinda in the chat.
Oh, right, okay.
What's the benefit with disability particularisation from the FIT?
Do you mean, sorry, I don't quite understand the question. Is that, what's the benefit of having the condition particularised?
What I was saying is, like, what is the benefit of our disability from the person of the fit to more like the disability?
Yeah, I mean, obviously you have to consider everything. So it's helpful if the fit note does provide you with as much information as possible with regard to what impairment the employee is suffering with. But you're going to need to speak with the employee or liaise with the occupational health expert about what impact or effect that condition is having on the employee's ability to conduct day-to-day activities. So the fit note is just one thing in a number of factual evidence that you will need to gather to determine the question of disability.
So is that all disabilities, Keeley?
It is, yeah, it is. I mean, obviously there's a list of implied or known disabilities. But in terms of something like depression, anxiety, mental health issues, or in this case, the long COVID, then you are going to need to look at each part of the definition to determine whether or not it is met at the relevant time.
Great, thank you.
So moving on then to the next case in the area of whistleblowing. The background to this case then is the law relating to protected disclosures. So protected disclosure means a qualifying disclosure, and a qualifying disclosure means any disclosure of information which, in the reasonable belief of the worker, is made in the public interest and tends to show one or more of the listed malpractices. And so in the legislation, the malpractices are listed. They include such things as a criminal offence, a breach of contract, as well as the health and safety of an individual has been, is being, or is likely to be endangered. And that's the one we're looking at in respect of this case. If then a worker has made a protected disclosure, they are protected from detrimental treatment because of making that protected disclosure. And in addition, if an employee is dismissed for making a protected disclosure, the dismissal will be automatically unfair. There is no minimum length of service requirement in order to bring that automatic unfair dismissal claim. And the compensation that applies to an automatic unfair dismissal claim in these circumstances is uncapped and will include an injury to feelings award. So these claims then are very similar to discrimination claims. So the facts of this case are that Ms. Fairhill had 38 years experience in the NHS and oversaw a team of around 50 district nurses. In 2015, Fairhill voiced concerns about a new local authority requirement for district nurses to monitor patients' prescriptions. She said it meant a sudden increase of around 1,000 extra visits a month for the service with no extra resources. So over the next 10 months, she made numerous reports about the health and safety of patients as well as staff. The death of a patient in October 2016 prompted a meeting in which Farhall suggested that the incident could have been prevented had her earlier concerns been addressed. And later that month, Farhall told a manager that she wished to begin a formal whistleblowing procedure. She then went on annual leave, but on her return, she was told she was suspended over allegations of gross misconduct relating to her leadership. She was suspended for 18 months, and after various investigations and appeals, she was dismissed in April 2018. She brought a claim of automatic unfair dismissal on the ground of making a protected disclosure. In the Employment Tribunal, then, the Judge Johnson, found that Farhall's complaints did amount to protected disclosures, even though she hadn't made those complaints formally through the whistleblowing procedure. So that's something of note, that a formal whistleblowing procedure does not need to be invoked in order for an employee to make a qualifying protected disclosure. The judge in the case said that the trust's investigation into the alleged misconduct had been inadequate and unreasonable in all the circumstances of the case, and had been designed to dismiss Farhall because she had made the protected disclosures. The tribunal panel ruled she had been therefore automatically unfairly dismissed. The trust appealed, but the Employment Appeal Tribunal dismissed that appeal in July 2021 and actually remitted the case back to the original Employment Tribunal that had made the first decision. Following a 2-day hearing in May of this year, the Employment Tribunal awarded Farhall £462,612.26 in compensation. And obviously I've not got the breakdown of that, but we're going to be looking at loss of earnings, injury to feelings, and interest. So that's significant compensation. So the lesson then to learn from this is that an employer does need to tread carefully when an employee has made complaints that could amount to protected disclosures. Once an employee has done that, they are protected from detrimental treatment or dismissal if that detrimental treatment dismissal can be linked back to their protected disclosure. If therefore a matter of misconduct does arise after an employee has made a protected disclosure, that must be reasonably investigated, which it must in any case. But an employer may actually probably fall short of maybe what they would usually do in the circumstances if an employee has got less than 2 years service. But of course, in these cases where an employee doesn't need the required 2 years service to bring an unfair dismissal claim, then the employer must, as I say, go through quite a rigorous disciplinary process or an investigation process before dismissing. So the next area then we're going to look at is, and I'll try and whiz through these. There's 3 of them in this area of discrimination with regard to the protected characteristic of religion or belief. So as I said at the start, it's peculiar that those 3 cases have been decided within the last 6 months. So the first of these cases then is that of Macarith and the Department of Work and Pensions. In this case, it dealt with a claim of direct discrimination. Now, as we know, direct discrimination, or the definition of it, is less favourable treatment because of the relevant protected characteristic. So in this case, it being religion or belief. So Mr. Macarith brought a claim asserting that he had been treated less favourably because of his religion or religious belief. He actually lost his claim in 2019. He had been a doctor engaged to carry out health assessments for the DWP. and he claimed he had been discriminated against because of his religious beliefs, as a result of him being dismissed for refusing to address transgender patients by their chosen pronoun. So his beliefs are based on what the Bible says in Genesis chapter 1, verse 27, that we are born male and female and that a person cannot change their sex or gender. And this belief conflicted with DWP's policies. In 2019, the Employment Tribunal determined that Dr. Makareth's beliefs were not worthy of protection under the Equality Act, and so did not fall within the protected characteristic of religion or similar philosophical belief. And as such, he lost his claim for discrimination on the ground of religion or belief. The tribunal ruled that his conscientious objection to transgenderism were incompatible with human dignity and conflict with the fundamental rights of others. The judge said his biblical beliefs did not meet the criteria to amount to a philosophical belief as defined in previous case law. Dr. Makareth therefore appealed to the Employment Appeal Tribunal. And what do you think? Well, in its 61-page judgment handed down on the 29th of June, the EAT ruled that Makareth's belief is protected under the Equality Act and the Human Rights Act. However, the judgment notes his belief could be deemed offensive. Justice Eady stated the ET had erred in its approach to question whether the beliefs were worthy of respect in a democratic society. The ET had wrongly considered the claimant's beliefs relative to his particular employment and had applied too high a threshold. However, she stated that the Employment Tribunal had properly taken account of the context in which Makareth had expressed his beliefs and had carefully evaluated DWP's concerns with them being expressed in his role. So the judgment says, given the particular context, it could not be said that the Employment Tribunal had erred in finding the measures adopted by the respondents were necessary and proportionate to meet a legitimate focus of the needs of potentially vulnerable service users and on the risks to those individuals and in consequence to the respondents. The EAT stated that the Employment Tribunal's finding thus drew a permissible distinction between the claimant's beliefs on the one hand, which are recognised as being a protected characteristic, and the particular way in which he wished to manifest those beliefs, and meant that his claim of direct discrimination had to fail. So in a roundabout way, what the EAT said is the claim fails, but not because of the fact that they couldn't reasonably determine that the belief wasn't a protected characteristic, but because of the way that M was manifesting or expressing those beliefs as part of his role or in the workplace, which was contrary to DWP's policies. Dr. Makareth appealed, therefore his appeal failed. However, he has suggested that he's going to appeal again. So we need to watch this space before I'm sure the matter will continue up to the Court of Appeal. The Christian Legal Centre, which supported Makareth with the case, described the judgment as confusing and muddled. It stated that the way in which the judge has driven a wedge between holding a belief and manifesting it means these basic Christian beliefs are protected on paper but not in practice. And the freedom to hold a belief but not to be able to express it is no freedom at all. So watch this space. The next case then on the same protected characteristic is the case of Kovalkov, I'll say K. The background to the case is it's a claim of indirect discrimination. So we're not dealing with direct discrimination in this case, but indirect discrimination. Just to remind ourselves then of the definition of indirect discrimination, a provision, criterion, or practice which is applied to all, but which puts persons with whom the complainant shares a protected characteristic at a particular disadvantage and puts the complainant at that disadvantage. And further, that cannot be justified. So the justification defence can kick in. So if there is a practice that potentially puts somebody at a disadvantage because of a protected characteristic, it can be justified by the employer. So the facts of this case then, Mr. K commenced employment and his belief was that he needed to wear, as an Orthodox Christian, he wanted to wear a crucifix necklace close to his chest as a symbol of his faith. He wore the necklace every day, including to work. When he commenced employment with the factory, it's a food factory, he was trained in the company's policies, including the policy which said that no jewellery other than a single plain band ring must be worn in the production areas. There was an exception in respect of religious jewellery, and that was subject to a risk assessment being conducted. The policy said jewellery with small links or chains must not be worn due to the risk of entanglement within the machinery. And the claimant's necklace actually did fit that description. He was initially asked by his immediate line manager to take the necklace off when she noticed that he was wearing it, and he did on that occasion, but subsequently he put it back on, unbeknown to her. He then made an allegation of bullying in January 2020, and when he attended that meeting, it was noticed by the line manager above his line manager that he was wearing this necklace. And so a question was asked as to why a risk assessment hadn't been conducted. As a result of that, the immediate line manager then conducted the risk assessment, and she was not best pleased that he had continued to wear the necklace, because if she had known that he was going to continue to wear the necklace, she would have conducted the risk assessment. So she'd been told off for not conducting the risk assessment, so she wasn't best pleased. So anyway, she conducted this risk assessment, and she determined that there was a risk of contamination, entanglement, entrapment, and tearing. She didn't bother to discuss the chain in any detail with the claimant, nor inspect whether it was in good condition. There was no conversation, as I say, with him about other steps that may have been taken to mitigate the risk, such as ensuring that it was tucked into his clothing or that his PPE could be fastened up to ensure it was not exposed. So nothing like that was investigated. Kay was asked to remove the necklace. He refused and was told to go to the HR office, who told him that he was refusing to obey a management instruction and would be dismissed with immediate effect. He appealed that decision, claiming that other staff carried keys or lanyards around their necks, but the company upheld the dismissal, stating he had failed to declare the religious necklace at his induction, and the lanyards were actually designed to break if they did get entangled in the machinery. Kay brought a claim of indirect discrimination on religious grounds to the Scottish Employment Tribunal. So in the tribunal then, it was confirmed that the policy to be considered and which was applied to all was the prohibition of wearing jewellery. The policy clearly put Kay at a disadvantage as it prevented him from wearing the crucifix necklace around his neck. So the first part of the definition then was satisfied. The issue therefore turned on whether or not the policy could be justified, i.e. was the policy a proportionate means of achieving a legitimate aim? So the legitimate aim of the policy was, of course, health and safety, both in respect of food contamination, i.e. the necklace falling into the food, but also against injury, so if it became entangled in the machinery. The Employment Tribunal dismissed Kay's claim, with the judgment stating that the company had been right to dismiss him as he had breached the jewellery policy. Kay therefore appealed to the EAT, and on appeal in February of this year, the Employment Tribunal's decision was set aside by the EAT, with the EAT ordering that the case be reheard again by the same tribunal. The decision then of the rehearing was announced in June this year, and the tribunal found that the application of the jewellery policy to Kay was not justified. So it's in effect reversed its previous decision. It decided that there was actually a less discriminatory way to have dealt with the matter. The company argued that the policy was applied proportionately because the risk assessment was carried out. But the tribunal considered that the risk assessment hadn't been properly or reasonably conducted. There had been no conversation with the claimant. There had been no investigation as to alternative things that could have been done to prevent the risk of the necklace falling into food or injuring him. And because of that, and the fact that the risk assessment hadn't been conducted properly, then that in effect resulted in him succeeding in his claim, and the tribunal deciding that the practice was not, or the policy was not justified in these circumstances. As a result, then, the claimant was awarded £22,000 and 74 pence, £22,074 and 68 pence in compensation, to include loss of earnings, injury to feelings, and interest. And it may have been that Kay mitigated his loss, i.e. obtained another job relatively quickly after he had been dismissed, and that's why potentially it was a relatively low award. The last case then in this area also deals with an indirect discrimination claim, and it's a case called Waters and Active Learning Trust. The facts of the case are that in June 2019, Reverend Keith Waters, who was employed as a caretaker at Isle of Ely Primary School, tweeted what is on the slide. This is outside the workplace in his capacity as a reverend from a private email account, or from a private account, Twitter account. He says, a reminder that Christians should not support or attend LGBTQ Pride Month events held in June. They promote a culture and encourage activities that are contrary to Christian faith and morals. They are especially harmful to children. A backlash ensued, including complaints made to the school from parents who had seen the tweet. Disciplinary proceedings were therefore commenced, and the school sent him a letter informing him that he was to be investigated for allegations of misconduct or gross misconduct for the making and circulation of comments which could be harmful to the reputation of the school. The investigation concluded the matter be referred to a disciplinary hearing on the 25th of June, but before that hearing commenced, Waters resigned, giving 1 month's notice. In his resignation letter, he said, "It has become absolutely clear to me that whatever your decision in respect of the proceedings you have launched against me, the Active Learning Trust and the school will no longer countenance freedom of expression, freedom of faith, and freedom of speech for any of its employees. That being the case, I have no choice but to leave your employ to ensure that my church and I are protected from being silenced." The disciplinary hearing took place, and Waters was given a final written warning, which confirmed that he had breached the policy when he posted information that was damaging to your employer's reputation, that was homophobic, harassing, discriminatory, and offensive. Waters appealed the decision, but this was not upheld, and he did not return to work, having already served out his notice. He then pursues claims of direct discrimination, i.e. that he had suffered less favourable treatment because of his religion or religious belief. He also claimed constructive unfair dismissal, asserting that the employer had breached the implied term of trust and confidence in the way that it had dealt with him. And thirdly, he brought a claim of indirect discrimination on the ground, again, of religion or religious belief. So what did the Employment Tribunal hold? The judge concluded that the reason why the claimant had been disciplined was because a parent had made a complaint, which then triggered the disciplinary hearing. This was the reason why the claimant had been subjected to the investigation and the disciplinary hearing and then the final written warning, and not because of his religion or religious belief. And therefore, the direct discrimination claim failed because the treatment wasn't because of his religion or religious belief. In addition, his constructive unfair dismissal claim failed because the tribunal said, in effect, he'd jumped too soon. He needed to have waited really until he had been issued with a final written warning before he resigned. If he had waited, he may have succeeded in a constructive unfair dismissal claim. In respect of the indirect discrimination claim, the tribunal said that he should succeed in that. The Employment Tribunal, first of all, identified the relevant policy, which was the disciplinary rules and the disciplinary policy, and that was applied to everybody. The tribunal identified that these policies pursued a legitimate aim, including of protecting the school and the trust, eliminating offence by its employees caused to others, preventing social conflict, and upholding its legal equality, obligation, and duty. The Employment Tribunal stated, however, that the fact that the claimant had made the tweet outside of his work from a personal account in his role as a Christian minister is highly relevant. And it's one thing to have policies and rules that apply in the workplace, and then it's something else to have them to apply outside of the workplace. Judge King added that to curtail the claimant's freedom of speech outside of work, which is an important part of his role as a Christian minister, and thus part of his freedom to practice his religion, must be done with some exercise of caution and only in the clearest cases where the rights of others are being damaged should the school intervene to prevent the claimant from preaching. The court said that actually there were less discriminatory ways that could have been managed, could have been used to manage the situation. The court actually said that the school could have issued a statement at an early stage to say that as a non-religious school, the claimant is entitled to have those views and practice his religion. But those views are not the views of the school, and they take equal opportunity seriously. And the court said that that may have prevented the complaints and the action that followed. So really, I mean, it's quite interesting, the last two cases in particular, where those claims of indirect discrimination succeeded primarily because, or only because, the courts decided that the justification defence hadn't succeeded. And it was all because there were, in the court's view, a lesser discriminatory way to have dealt with the situation. So when you are dealing with a policy that can potentially, or a practice or a criterion that could potentially disadvantage somebody with a particular protected characteristic, it is really important to be able to investigate whether or not there is a more reasonable, less discriminatory way. of enforcing that policy in respect of that individual in those circumstances. Okay, I'm going to jump then to the next topic of agency workers. So this is the case then of Coker and Angard Staffing Solutions Limited. The background then to this case is the agency workers regulations, which are obviously intended to give effect to the Temporary Agency Workers Directive, European law. The agency workers regs must, so far as possible, be read in a way that gives effect to the directive. The recitals to the directive are clear that the intention is to strike a balance between the protections of the agency worker on the one hand, and then the benefits in terms of flexibility of the use of agency workers on the other. Article 6 of the directive is concerned with the provision of information about vacancies, and it provides the following. Temporary agency workers shall be informed of any vacant posts in the user undertaking to give them the same opportunity as other workers in that undertaking to find permanent employment. Such information may be provided by a general announcement in a suitable place in the undertaking for which and under whose supervision temporary agency workers are engaged. The corresponding then regulation, which is Regulation 13.1 of the Agency Workers Regulation, is as follows. An agency worker has, during an assignment, the right to be informed by the hirer of any relevant vacant posts with the hirer to give that agency worker the same opportunity as a comparable worker to find permanent employment with the hirer. The hirer may inform the agency worker by a general announcement in a suitable place in the hirer's establishment. So in effect, reciprocal rights, the regulations implementing the directive in terms of the agency worker being informed of the relevant vacant posts. So in this case then, facts, Mr. Coker, an agency worker, was deployed into the Royal Mail Group. The agency was Angard. It supplied agency workers on a flexible basis exclusively to Royal Mail to enable them to respond to the fluctuations in demand for postal workers. So Mr. Coker then was supplied by Angard to Royal Mail to work in a mail centre. Vacancies for permanent positions at the mail centre were put on a notice board and offered first to direct employees of Royal Mail. Agency workers were not eligible to apply. If vacancies were advertised externally, then agency workers were entitled to apply in competition with other external applicants. Mr. Coker complained to the Employment Tribunal that he believed that breached Regulation 13. So what did the Employment Tribunal say? Well, the tribunal upheld Kay's claims. It held that the express right to receive information in Regulation 13 extended an implicit right to apply for the vacant posts. Angard therefore appealed to the EAT. The EAT disagreed with the Employment Tribunal, holding that, properly construed in light of the directive, the right was only to be notified of the vacancies on the same basis and with the same level of information as directly recruited employees. There was no right to apply and be considered for internal vacancies on the same terms as direct employees. And as such, the obligation was satisfied if the temporary agency workers were informed of the relevant vacancies, even if they were not given the opportunity to apply for them. Mr. Kay therefore appealed to the Court of Appeal. And the Court of Appeal agreed with the EAT and dismissed the appeal. So what did the Court of Appeal confirm? It basically said that, read literally, Article 6 of the directive, which is implemented by Regulation 13, only provides a right to be notified in the same way as direct employees of the hirer. It agreed with the EAT to say that that right does not imply a right to be given the opportunity to apply for those vacancies. The court also confirmed that a right actually to be notified of the vacancies is a real advantage, because it basically says that it meant agency workers would have potentially advance notice of a vacancy if it was then advertised externally, so an internal candidate didn't apply. The court confirmed that if the intention had been to provide agency workers with the right to apply for a vacancy, then that would have been clearly stated in both the directive as well as the regulation. So, I mean, this has been quite a long running case, obviously confirmed this year, but it does obviously recognise agency workers are not in all respects comparable to permanent workers, although it did seem that the law was going that way. It will be obviously reassuring to employers who use agency staff. Hirers of agency workers will welcome that court's conclusion. Moving then on to vicarious liability. The case I want to draw your attention to on this is that of Chell and Tarmac Cement and Lime Limited. The facts of the case are that Tarmac engaged Mr. Chell at a quarry site. Mr. Chell had reported tension between external contractors and employees of Tarmac to his supervisor. Subsequently, an employee of Tarmac played a prank on Mr. Chell. He brought explosive pellets, would you believe, into work and hit them with a hammer very near to Mr. Chell's ear. And the explosion resulted in Mr. Chell suffering a perforated eardrum, hearing loss, and tinnitus. So Mr. Chell brought a claim for personal injury against Tarmac, arguing that Tarmac should be vicariously liable for the employee who did this to him or caused the injury. The county court decided that he shouldn't succeed in that claim, that Tarmac shouldn't be held to be vicariously liable. So Mr. Chell then appealed to the High Court, who upheld the county court's decision, and therefore he decided to appeal to the Court of Appeal. It must have cost him a fortune, but he carried on. The Court of Appeal dismissed the appeal. The court confirmed that there was not a sufficiently close connection between the act which caused the injury and the employee's work to make it fair, just, and reasonable to impose vicarious liability. Among other things, the real cause of Mr. Chell's injuries was the explosive pellet, which was not Tarmac's equipment and not used in the employee's work. It could not be said that Tarmac had authorised what the employee had done, nor was his act an unlawful mode of doing something authorised by Tarmac, and therefore the wrongful acts were not done in the course of employment. Of course, this decision seems, in my view, and I'm sure yours, as common sense. But what the court decision does do is highlight that in some circumstances, of course, an employer will be vicariously liable for the acts of its employees. It may not be in terms of a prank, but actually if something is being done in the course of employment, or the employee's equipment is being used in the prank, or there is going to be some risk that the employer is going to be vicariously liable. but helpfully common sense prevailed in this case. Right, yes, the holiday pay claim case that I wanted to bring your attention to is the long-running Pimlico plumbers case, or one of them. The headline of this case then is that the right to take paid annual leave does not necessarily lapse at the end of the relevant holiday year, but can carry over and accumulate until the contract ends. So that is the message and the headline in this case. The facts of the case are that in 2018, the Supreme Court ruled in Pimlico Plumbers and another in Smith that an individual engaged by Pimlico Plumbers between 2005 and 2011 had been incorrectly classed as self-employed rather than a worker. And I'm sure you'll have seen these cases going through. I'm sure I've touched upon them in the updates, that these cases were brought on the basis that the plumbers were workers and not self-employed. And of course, Pimlico was saying you are self-employed, and they're saying, no, we're not, we're workers, and therefore we're entitled to all these rights, including holiday pay. So last year then, the Employment Appeal Tribunal upheld the Employment Tribunal's 2019 ruling that Smith had not filed his claim for backdated holiday pay quickly enough. So under the tribunal rules, he should have made his claim for missed holiday pay within 3 months of the end of each holiday leave year or leave period, dating back then to 2005. So on the basis of limitation, being out of time, they said he cannot pursue his claim, because as I say, he needed to have brought his claim within 3 months of the end of each leave period, which obviously he didn't do. So, however, then in the last month, the Court of Appeal ruled that Smith was entitled to be paid for up to 4 weeks' pay, and this is the leave requirement under the directive under European law rather than the UK working time working time regulation. So it's 4 weeks. For up to 4 weeks paid leave in respect of every year he worked for Pimlico Plumbers, where leave had been taken but was not paid. This meant that he should have received 4 weeks pay in respect of every year he'd worked for the company. And that claim crystallised at the end of his contract. So in effect, he was able to bring that claim for backdated holiday pay since 2005. So obviously this is a pretty significant ruling, and it does overturn a lot of the previous decisions. It leaves employers pretty vulnerable because of claims potentially by workers when their engagement with the company ends, and the right then to take or to be paid on taken holiday at that point crystallises. Within the judgment, Lady Justice Simler stated that in order to discharge the employee's right to claim without limitation, meaning that workers would only be able to claim for any unpaid leave in respect of the current holiday leave year, an employer needs to show the following. So this is to try and dispute claims of backdated holiday pay. So what an employer needs to be able to show is that it specifically and transparently gave the worker the opportunity to take the paid leave. Secondly, that it encouraged the worker to take the annual leave. And thirdly, that it informed the worker that the right would be lost, i.e. carryover of holiday would be lost, unless they took the holiday in the relevant leave year. So what's the risk for the employers? What we need to make sure is well, the risk obviously is an influx of claims by any worker who may have received an underpayment of holiday pay in previous years, even if they hadn't taken the holiday for a number of years, because as I say, the claim or the right to claim crystallises on termination of the contract. Claims by workers could be in respect of up to 4 weeks leave in respect of each holiday leave year, i.e. the EU derived annual leave entitlement, not the UK entitlement of 5.6 weeks. And it's for every year worked without limitation of how many years such leave has been unpaid. And so the normal 2-year backstop is now questionable and doesn't apply. So it's quite a big decision. So this means that the financial burden on businesses could be significant. In the case in question, the individual was actually awarded £74,000 of holiday pay, which covered his 6 years service. Although the right to be paid only crystallises when the individual leaves their job, it could be risky strategy for employers to not take steps to try and mitigate the risk now because of the potential future financial burden. So there's 3 ways or 3 steps that an employer could adopt or take now to try and mitigate the risk. Consider the wording of your contracts. Make sure that it's very clear that holiday cannot be taken from 1 year to the next. Also review your current relationships. As I say, this case related to an individual who was determined to be a worker, but who the employer stated was self-employed. So if you have got, as it were, self-employed contractors working for you, please consider whether they could be workers or could be employees. It's a very factual assessment. So although the contractual documentation between an employer and a self-employed individual may dictate that they are in business on their own account, the factual scenario may paint a different picture. So analyse those relationships and keep on top of them. Things may change. And then thirdly, do everything you can to mitigate the risk. So communicate with the individuals concerned, make sure that workers and employees are taking their holiday or are asked to take holiday, notified of their holiday, and not prevented from taking their holiday. As I say, the case does mean that back pay can or the pay for annual leave that they say hasn't been granted to them in previous years, the claims may be made in the future on termination. So bear that in mind. I'm going to leave this next case of sex discrimination because I'm mindful of the time, but just moving on to the last section of the huddle is about the changes on the horizon, and I'm just going to skip through these. So there are some things that it's worth noting that may be legislated on in the future. We've got, with regards to the area of sexual harassment, potentially introduction of a statutory mandatory code to deal with that, whether that's a process or procedure that employers have to follow, we shall see. There's also changes on the horizon with regard to settlement agreements, and that's relating mainly to confidentiality clauses. I get questions a lot of, well, what is this confidentiality clause and what is it worth? How can it be enforced? So I think the main objective is going to be an explanation as to what the repercussions are or could be if confidentiality provisions are breached in settlement agreements. Also, with regard to flexible working, the removal of the requirement to have 26 weeks continuous service, allowing employees to make more than one request in every 12 months, a reduction of the 3 months time limit for employers to deal with the requests, and to require employers to consider alternative working arrangements when rejecting a request. Also, the introduction of a statutory carers leave and neonatal leave to be introduced, as I say. Further redundancy protection in respect of employees returning from maternity leave. So, as we all know, in a redundancy situation, a employee on maternity leave has to be considered ahead of everybody else in respect of vacancies, and it is proposed that that protection will be extended for a further 6 months on return to work. Requests for a more stable contract. Now, we've seen that movement in respect of 0 hours contracts, but it may be progressed into other scenarios with respect to potentially low earning employees. More protection in the area of data protection. Additional requirements in respect of modern slavery statements. And then lastly, other matters, a whole range of other matters, including extending the time required to break continuous employment. At the moment, it's a full week from a Sunday to a Sunday. They're looking at extending that to a month. Widening a ban also on exclusivity clauses and replacement of Human Rights Act with a Bill of Rights. So that is the whistle-stop tour. I will send the slides to you, Eloise, so that has got a bit more information in, particularly with regard to the changes. So then if you've got any questions about those, then obviously you can let me know through you, if that's okay.
Yeah, perfect. Thank you.
And there we are. If there's any questions, hopefully I've not run over too much.
No, I think that's fine. Just a few minutes. So Keeley, thank you. You've been really informative as ever, really interesting. Thank you everybody for joining us and attending. If you've got any questions, then feel free to contact me or contact Keeley to directly with her contact details. But I'll send out the slides this week. The recording will follow, so bear with us. We'll get the recording to you as soon as we can. But we'll be back after the summer break, probably September time, with some more webinars. But yeah, lovely to see you all. Thank you very much for your time. Speak to you soon.